Hey everybody, Eric Worral here with rentprep.com, and this is another episode of Attorney Advice, and he might be looking familiar to you hopefully by this point. We got Don Krupens here, who is an attorney out of, your firm's name is Lawvex, is that correct?
Yes, Lawvex.
Lawvex, and you represent landlords and small business owners in the state of California. Don's a great resource for insights, and it's very helpful because today I think is a very important topic, which we've covered in the group before, but we kind of want to go a little bit more in depth. And we're talking about move-in, move-out condition of the premise. So once again, Don, thank you for being on the segment here. And I'm just going to kind of toss the ball into your court and let you kind of talk to us about what you'd recommend and what your experience with this has been from a legal perspective.
Sure. As Eric introduced just a moment ago, I know that there's no shortage of information out there about, some of the practical steps to take, upon a tenant moving in as well as a tenant moving out. I wanted to highlight a couple things that are truisms in California, specifically related to California law. It may be prevalent in other states, and then kind of talk to you a little bit about evidence, if you will. Ultimately, what you're doing is you're creating a body of evidence in case a dispute arises. So I just wanted to talk a little bit about how that might play out in court if, unfortunately, you do wind up making your way there.
Okay.
So California is not unlike most other states. There are no legal requirements for a move-in or move-out inspection. It's really a great business practice. It makes sense. If we give our car to the mechanic, it's not uncommon for us to do a walk around afterwards to make sure there's not a ding in the door that wasn't there before we dropped it off. It makes sense that you would do the same thing with your home or a duplex or whatever type of tenancy environment you may have. One of the things that again, I'm not sure how unique it is, but I find a little bit unique in California is if the tenant gives the landlord notice that the tenant is going to be vacating the premises, the landlord has an obligation to notify the tenant that the tenant is entitled to a pre-move out inspection by the landlord.
Okay.
If the tenant exercises that right, then the landlord must make arrangements to inspect the premises. Ideally, it should be consistent with how the move-in inspection was done. The purpose of the inspection, again, as you guys know, is to kind of note any defects or damage. Ultimately, the goal is to give the tenant the opportunity to cure those defects so that you don't get into an issue with security deposits and withholding things possibly improperly or properly, but the tenant alleging that you are withholding them improperly.
Sure.
The other aspect of it that's kind of nice too, and this is kind of my recommendation too for landlords, is even though California requires a landlord to do that if the tenant exercises that right, the landlord still has an opportunity once the tenant has vacated to go in and look for either hidden conditions that weren't revealed at the time of the inspection. Maybe there was a couch in the way of the wall, or or maybe there was some damage that occurred between the inspection when they moved out. They ran that same couch into the door jamb as they were carrying it out the front door. So again, strongly recommend them. In speaking with Eric before we started, I know there's information about taking pictures and documenting and things like that. And I want to just roll into kind of some evidentiary stuff. And for those of you that are unfortunate enough to wind up in court, I don't think it's a place that anybody should aspire to go. It's usually not a fun process. It takes time. It can be expensive depending on the nature of the issue. One of the things that you can do to reduce that burden if you do wind up in court is to really make sure that you have well-documented and well-thought-out evidence. And that's really what I wanted to talk about the move-in and move-out inspection. Pictures are great, but one of the things that you will need to establish, again, depending on how strict the judge is when those photographs were actually taken. One of the things that I would recommend if you're going to take a photographic record, specifically a digital photographic record, which in today's day and age is what I would recommend, I would immediately send that information to the tenant. Send it in an email. Make sure you have, email today, time, and date stamps everything. Then that becomes your record of having communicated the particular condition of the premises at the time, at least insofar as the photographs go.
Well, that's really interesting because we've talked a lot in the past about like doing one of those date stamps, and an app on your phone that helps put a date stamp on. But obviously, that's something too that could be doctored after the fact. But what you're talking about is having that email correspondence that a tenant responds to and says, "Got it, thanks," and then you can have that date and time with those specific photos as well.
Yeah, absolutely. I think you raise a great point. There's almost not a piece of evidence out there that isn't subject to some type of manipulation.
Mm-hmm.
I think for communication and the trail that email communication leaves is less susceptible to question than other forms of communication. So the same with your walkthrough, your initial walkthrough inspection. I would do the exact same thing. Send it via email. Obtain some acknowledgement from the tenant that they've received it. Give the opportunity to the tenant to disagree, and make sure insist on a meeting of the minds at the outset of the tenancy, as opposed to trying to figure out what you thought you both meant 12 months later or 24 months later, or whatever the period of the tenancy may be. So that's a great way to kind of preserve your evidence. To the extent that damages occur, or you learn of damages throughout the course of the tenancy, whether repairs are made or not. I mean, there's some things that a landlord may choose not to repair because it's minor in nature. Again, this theme keeps coming up: document. Create an email trail. To the extent that you can ever get a tenant to acknowledge either your observations or a conversation you had, I strongly recommend you do so in email if possible.
Well, yeah, one of the an acronym that I heard from another attorney was the ABCDEs of property management, and it's always be consistent, document everything. And I was like, that's so simple, perfect, works. Everybody should be doing that.
Yeah, and it's funny you say everybody should be doing it. I can tell you from my experience that not everybody does. Property management as a profession or even a hobby for some is difficult. Don't make it any more difficult on yourself by not following a few simple steps. With respect to move-in and move-out inspections, document, communicate, obtain acknowledgement of that communication, and certainly if you're ever questioned or the matter ever presents itself before a judge, it's going to be that paper trail and that communication acknowledgement that will likely, I make no promises about what a judge is going to do, but it can be very persuasive.
Yeah. And there's also tools out there too. I mean, Google Voice and also your Gmail. I mean, you can put labels on emails very easily that are from certain people. You can create an entire email account that's just specific to your rental properties. I know there's probably laws as far as recording conversations from Google Voice, but I do know that we have a property manager that we talked to on the podcast before who does all their rental listings through the Google Voice. They got a discrimination claim against them, and he was able to go back through, and the way his process was set up is that you had to leave a text through this Google Voice number. And this person never texted them. There's no history of this person ever saying, I want your rental application. And this person was claiming that they did, and they also claimed discrimination that they didn't get the rental property. And he goes, here are all of my texts for that entire month. This person never went through the process. So this guy, he was able to get around this discrimination. I shouldn't say get around it. He was able to prove that he was not discriminating because he's documenting his process, and he also was putting the tools in place to help himself. And I thought it was pretty smart doing it that way. And the more refined your process, I believe, the more you can realize, like, all right, let's have a little hurdle right here that's going to stop somebody. They need to text me for the rental application, and if they don't do that, then obviously we never got to that part of the process. So I thought that was really interesting.
Right. Yeah, no, that is very interesting. One of the things too that I have found, particularly with individuals who are renting out a home, some folks believe their home is actually a lot better than it really is.
Sure.
so you wind up.
I just have a new baby, and let me tell you, he's the cutest baby in the entire world. Unless you ask my neighbor, So
who has the cutest baby in the entire world?
And I think especially landlords who lived in the house. Like I owned a double, I moved out. I'm sure I look at that property a lot different than my tenants do or the neighbors do.
Yeah, and it invariably can give rise to disputes, particularly when it comes time to move out. So, Eric, you had mentioned something earlier about third parties doing inspections,
Mhm.
and I know that there's professional organizations that do it out there, and I don't know, and I haven't really thought through this that much, but I'm going to go out on a limb and say maybe you have one property and you don't want to incur the cost of having a private company do it.
Mhm.
Maybe find a neutral third party that would be willing to do it. Maybe it's a friend, maybe it's a mutually agreed upon person that both you and the tenant, agree upon, that will look at the property with a more unadulterated eye
Mhm.
than the homeowner who thinks it's fantastic, the tenant who doesn't nearly see it as favorable as the landlord does.
Sure. Yeah, absolutely. Do you have any other suggestions? I mean, as far as move out, I know this is probably an entire other subject, so I don't want to go too far down the rabbit hole, but people get really caught up in what can I charge for and what's wear and tear.
Yeah.
General rule of thumb, what would you tell people with that?
The rule of thumb is there isn't one. I mean, it's
Okay.
that's the hard part. Wear and tear is about the most nebulous term that I think I've ever heard, and there's a lot of them in the legal profession.
Sure.
So again, I would, and this kind of goes back to what we were just saying a moment ago. It may be your childhood home that you've rented out, but if the carpet has been in there 20 years,
Mhm.
it's worth nothing.
Okay.
So if it gets damaged, something that's worth nothing that gets damaged is still worth nothing.
Mhm.
So again, try to remove yourself from it. Wear and tear, I think you kind of have to step back and think about how an ordinary individual would use a home. I know this is not helping. Probably most people listening to the podcast go, "Oh, okay, that's what I need to do."
Yeah.
I was so just a couple things that I've encountered. Nail holes for pictures. Pretty ordinary. People hang pictures. But if they're using a 1/4 inch, a railroad spike to hang their pictures, not ordinary wear and
Mhm.
tear. If the carpet was cleaned and stain free when the tenants moved in, and now after cleaning, when the tenants move out, there's still stains in the carpet, again, attributed to the tenants, not normal wear and tear.
Mhm.
So, around light switches or switch plates, that's where our hands are all the time. That stuff gets dirty. That's, ordinary wear and tear. Some of it may be easily cleaned. Some of it may require repainting.
Mhm.
On the other hand, if you see handprints on the ceiling, well, that might not be ordinary wear and tear. It's not a place that we would normally expect handprints to be for somebody who's using a home kind of in the ordinary course of tenancy.
Mhm.
So it's a really difficult area. It really goes back to kind of your move-in inspection, and which is to establish a benchmark for how the home should be returned to you.
Mhm.
And if upon receipt of that home after the tenant or whatever dwelling it is not really close to how it was received by the tenant, I would say that's probably when you're getting away from normal wear and tear.
Okay.
Again, it's a gray area. It's hard. It is very, very fact dependent,
Mhm.
and it's hard to kind of broad brush good tangible advice that somebody could walk away with. But
Yeah. I know I've seen like some people have like these sheets and they're like, this is what we do for the fridge. It's like amortized by this much each year. Or I don't even know if I'm saying that correctly, and like this is what we do for the carpet. This is how much it costs for this and this. And I'm like, I guess, but I'm like, I don't think that's anything that's actually legally necessarily like binding. I think it's just something that somebody just came up with. I don't know what your thoughts are on that.
Yeah, I think ultimately, to your point, I think you're spot on. I mean, you're going to have to get somebody in who could, what is depreciation for carpet over 10 years? What is depreciation for an appliance? You're going to have to get an expert to come in, which is not in the legal environment that most people might find themselves in, which is going to be small claims court or an unlawful detainer action.
Yeah.
This is not an appropriate forum to raise those issues.
Yeah,
So,
gotcha. You'll win $1,000 that you may not collect on, and you'll have $1,200 in attorney fees.
Yeah,
Getting a professional in, or
Exactly, for maybe what would have cost $500 to replace carpet for.
Yep.
So,
or maybe even meeting the tenant halfway if the relationship is capable of doing that at that point.
Absolutely, negotiations can be a fantastic way to a good outcome.
Okay. Do you have anything else you want to add to move in, move out inspections?
No, sir. Again, it's a challenging area for landlords. Know the law. Know when you need to refund security deposits. Know the basis for withholding. I know California tries to do a really good job of laying out what you can withhold for and what you can't.
Mm-hmm.
If I could plug a government website real quick for all the California listeners out there, and it may just be insightful for folks outside the state of California. It's the Department of Consumer Affairs. They have a whole landlord-tenant handbook out there. I think it's upwards of 200 pages. I mean, it is fantastic and filled with information. I know it's all available online. So good resource for not just California folks, I think insightful for others as well.
Yeah, I think I've actually read through some of that, just making content in the past. And the thing that I always found the funniest was you're allowed to charge a half month's more security deposit if the person has a water bed.
Right. Yeah. Exactly.
And I was just like, I love it. It's so specific.
I know.
So
and
in case
it's furnished, then it's
if you have a tenant, with a time machine, and you go back to the 80s, 90s, and everybody's got water beds, So
right. Yeah, I know. I had one when I was a kid. So,
yeah. My brother had one. I was very jealous.
Yeah, that's funny. But no, I think again, just be aware of the law out there and document. And lastly, I think I would say be reasonable. Mm-hmm. If you have a fairly significant repair, let's say you have to replace a door, I would get a couple estimates. If you're not going to repair it yourself, get a couple of estimates on what that work would cost. Mm-hmm. Maybe split the difference if they're relatively close. I wouldn't automatically go with the highest bidder and then go with the cheapest contractor once you get paid or once you withhold the money. So this is I guess my final tip.
All right. I love it. Yeah. Thanks again for the insights here, because I know it's definitely something that's hotly debated amongst landlords. So, and you can always just use that standard rule of thumb too, be kind. We're not here to gouge people, but you want to make sure that you also are protecting your rental investments and making sure that you're not being taken advantage of at the same time. So if anybody wants to reach out, they can always get me, Eric Worral here, or Don in the Facebook group, and that's a great way to connect with people and ask questions. So can't thank you enough for being on today here. Thanks.
My pleasure. Thank you, Eric.
All right.